Hi, welcome everyone. We'd like to welcome you to our Native Nations Law and Policy Center presentation regarding confidentiality and tribal cultural resource protection. I'll give a few minutes just to give everyone a chance to log in to our virtual presentation, and then we'll get started. Okay, well, greetings. My name is Lauren Van Schilfgaard. I am a tribal member of Coche de Pueblo. I serve as the director for UCLA's Tribal Legal Development Clinic, and I am very excited to welcome everyone here today. I'd like to highlight Professor Angela Riley's beautiful face. Unfortunately, her audio is not really functioning right now, but she wanted to give her greetings and gratitude to all of you here today. I am also delighted to feature our two panelists. We have Dr. Wendy Teeter. If you'd like to say hello and introduce yourself.
Hi, everyone, and it's great to see so many familiar names. I would love to see your faces, but I know you're there, so it means a lot that you're joining us here today. I'm Senior Curator of the Fowler Museum at UCLA and UCLA's NAGPRA Coordinator. And as of August 1st, I'm also the Cultural Resources Archaeologist for Indigenous Band of Chumash Indians.
Thank you, Dr. Teeter. I'd also like to feature Sam Cohen. Hi, Sam.
Hi, Lauren. Sam Cohen, zooming to you from the San Ynez Indian Reservation, where I'm the Government Affairs and Legal Officer. Nice to meet you all.
I can't tell you how excited I am to be featuring this panel. Before we get started, I'd like to give a land acknowledgement for at least where I am sitting. UCLA would like to acknowledge the Ganverli Tongva people as the traditional land caretakers of Pavangnar, also known as the Los Angeles Basin and the Channel Islands. As a land grant institution, we'd like to pay our respects to the ancestors, the elders, and our relatives and relations, both past, present, and emerging. I would also like to acknowledge the Fernandino Tataviam, the ancestral caretakers for my home in Burbank, California, as well as the Chumash people, for which we are delighted to be joined by some today. Today, we would like to discuss a relatively niche area, though it seems to have lots of rippling effects in lots of various ways, and that is the need for confidentiality protections, or at least enhanced and meaningful confidentiality protections, particularly within the realm of tribal cultural resource protection. Because we are joined by both Dr. Teeter and Mr. Sam Cohen, we have the privilege of having access to incredible expertise, both academically as well as practitioner-based expertise. So I am very excited to dig into some of the meat here. We're on Zoom, which of course has its pros and cons. The pros is that we all get to be here today with minimal travel. I don't get to see any of your faces or react to your body language, but I do have access to a question and answer box. I warmly invite you to take advantage of that. While our speakers are sharing their stories, I will attempt to facilitate that question and answers and highlight some of the questions so that we can get them to them today. So I encourage all of you to really take this as your own session, especially because you're bothering to join us live. Please ask questions. In the meantime, I will attempt to sort of frame the issue, and that way we can tee it off for our speakers. This topic was really directed to me by Dr. Teeter, who sort of presented this as an issue that mandates in-depth attention. I think there has been a lot of really great substantive work that has poured into specifically scholarship-wise on tribal cultural resource protection, but the actual work of protecting cultural resources is frequently bogged down in administrative secrecy. There is sharing of information, and unless you are actively engaged in that work, the exposure and the price of that exposure is not really well known. And yet I think tribes that are engaged in this work are very aware of the risks that they take on when attempting to protect their cultural resources. So when we say confidentiality, we really mean the ability and the right for tribes to dictate what of their information can be shared beyond the confines of the negotiations engaged in cultural resource protection. There are a variety of types of information that we attempt to sort of use an umbrella term of tribally sensitive information. And by that, we just mean information that a tribe may or may not want to be out in the public sphere. This can be a variety of different things. There's the classic information that I think Westerners frequently come to when they think about cultural or confidential information, proprietary information, things that are about, money-making endeavors. There are also culturally sensitive information that tribes may not want to share publicly. This might include things regarding cultural practices, ceremonies, rites, language. It could be about the specific geographic location of certain sites, both because we don't want to publicize that this is where the nefarious Indiana Jones wannabes should be digging, but also because it may not be appropriate to share the location of that even within the tribe. There may be cultural protocols that dictate how certain information can be shared with whom, when, and at what time. And then there's really everything in between. And yet, even though tribes have lots of really complex and nuanced information and ways that that information should be handled, tribes appear to have the least amount of access to confidential protections, at least under US law. So because of this, there was sort of this anecdotal sense that this was true. So Dr. Teeter approached the clinic asking for can you actually look at this? Can you actually document what's going on in here? So I was like, oh, okay, we'll attempt to do that. And so the clinic produced this white paper that basically tried to walk through some of the cultural resource protection statutes, at least some of the big ones. It turns out this is a huge area of the law, and there's a lot going on, both under federal, state, as well as under tribal law. So we just took kind of a snapshot and then attempted to look at where are the gaps here. It turns out there are, in fact, some really alarming gaps, both within the statutes themselves, but also philosophically. There's a clear miscommunication going on about what tribes want and need and what federal and state agencies are willing to give. Some of this, I think, is malintentioned. A lot of it, I think, is just misinformation. We didn't think about this. It didn't occur to us. We didn't appreciate that tribes were having these internal debates about how information should be shared. And if we had known that, maybe we can accommodate a little bit more. This is me attempting to be diplomatic. That may or may not be the case. And I think as Dr. Teeter and Mr. Cohen go into a little bit more, sometimes that isn't the case. What we did find is that confidentiality as a resource, as a tool, is rarely built into some of these statutes. Further, traditional knowledge, tribal knowledge, oral knowledge, knowledge that originates from the tribe and isn't duplicated in some academic journal or other scholarly research, is tended to be considered of less value. It's less worthy of protection. It appears that protection, the sole metric, is monetary. And so to the extent that tribes don't assign that type of monetary value, even though it is highly valuable to the tribe, is thereby provided less protection. in part related to that, traditional knowledge is generally considered to be less reliable, less probative value. So when tribes are engaged in cultural resource protection and are attempting to prove, say, cultural affiliation with a certain resource that they are attempting to repatriate, if tribes are relying on their internal traditional knowledge, they're compelled to reveal more of that information than they might otherwise if there was an academic citation that they could also rely upon. And so the exposure of this confidential information is exacerbated because of that. Finally, I think we find this in various statutes, but certainly in cultural resource protection, the decision maker, the entity that actually gets to dictate whether or not there is cultural affiliation or whether or not this information is going to be confidential, is always an outside entity, and it's frequently an entity that has an interest in exposing that information. The tribe rarely has an opportunity to mandate that something is confidential. And many times they rarely even get notice that something is going to be exposed. And so for all of these reasons, it's like, all right, there's a problem here. For those of you that practice in this area, and by some of your names, I can tell that you do, and you're experts in this, you know that there is a lot of stuff going on here. Even just from the federal landscape, there's a lot of statutes, in part because there has not really, I think, outside of NAGPRA, been a statute that was specifically designed to protect tribal cultural resources. It just doesn't really exist. Instead, tribes are playing this hodgepodge game of leveraging various federal statutes in order to develop a cohesive protective unit. So this has included using the Archaeological Resources Protection Act, or ARPA, the Cultural and Heritage Cooperation Authority, which has great language, but not a whole lot of oomph, the NEPA, the National Environmental Policy Act, the National Historic Preservation Act, where a lot of this work ends up happening, NAGPRA, the Native American Graves Protection and Repatriation Act that I mentioned, as well as some executive orders and stuff like that. On the state side, at least within California, we also have some of these federal statutes that have been sort of domesticated and slightly expanded on in state law. And that includes the California Environmental Quality Act, or CEQA, as well as the flip side, the statutes that enable the release of this information, such as the Freedom of Information Act, or FOIA, on the federal side, and on the California side, the California Public Records Act. So all of this is all happening at the same time, which means both the agencies as well as tribes need to be able to be nimbly jump from all of these while attempting to really, like, what are we doing here? We're attempting to protect or at least mitigate harm to our cultural resources, particularly those that are located off of our tribal lands, while also protecting and at least mitigating harm to the information that we are compelled to expose while going about the protection of these cultural resources. So, I mean, this is the tale of contact for tribes, but tribes are constantly in this catch-22 dance of, in order to protect A, I have to sacrifice B, and vice versa. There are so many instances in which tribes have relinquished and sort of resigned that a cultural resource may be harmed or destroyed because the alternative would require exposing information that is simply not worth exposing. And that's a problem. That's a problem. It, for no other reason, exemplifies that the dynamic is not a true nation-to-nation dynamic. Tribes are not being afforded the sovereign respect that you think would inform these types of negotiations. And instead, the fact that they have information that is near and dear is being used to leverage the tribal position to their disadvantage. So we have identified, just in this white paper, a couple of specific problems. These include that the confidentiality protections that do exist in these statutes, which there are some, but they are extremely limited in scope. They rarely have tribal information in mind. And so tribes are trying to pigeonhole their information to fit in maybe, say, a historic property box or an archaeological resource box. They also are purely at the whim of the agency's discretion, an agency that is rarely positioned aligned with the tribe. Tribes frequently don't have a right to notice when their information is going to be exposed, say due to a FOIA request. They certainly don't have any consent to veto an agency decision that might be exposing their information. There's lots of instances where the statute provides third-party access to information, such as via an audit. And then, as I mentioned, there is this inherent bias against traditional knowledge to both devalue it as well as to clamor for its access. It almost appears that agencies feel like it's their job to help publicize a lot of this traditional knowledge, which is interesting. We go through some of the FOIA exemptions. Suffice it to say, FOIA exemptions, which are sort of opportunities to try and get out of having to comply with the FOIA request, have not been very useful to tribes. Back in the 70s, there were actually 2 congressional attempts to enact an Indian FOIA exemption. Those have not gone anywhere. Congresswoman Haaland, when she was in Congress before she became Secretary Haaland, actually introduced a FOIA exemption specifically to NAGPRA. It is currently still sitting in committee, which is jargon to say it's dead. But at least that it was the first glimmer of something since the 70s. So in the meantime, tribes have had to strategize around this. They've had to figure out how are we going to negotiate ourselves around this. And this has included a lot of really creative strategies, including leveraging the verbiage that is in these statutes, negotiating memorandums of understanding with agencies, pushing for consultation regarding these issues, and then holding cards close to the chest, being really strategic about what information is shared and in what form. And so towards that, I would like to turn it over to some of our speakers to really give light to some of these issues and how they are playing out in real time, and how many of these issues are incredibly nuanced. And so with that, I would like to turn it over to Sam Cohen. I see in the comments, is the white paper available? Yes, it is. I will put a link in the chat while we turn it over to our speakers.
Thank you, Lauren. Sam Cohen here. I did work a little on the white paper, and I benefited from the white paper because at around the same time it was issued, I was approached by NASA telling the Seni Inez Band that NASA was subject to a Freedom of Information Act request, and we had been jointly working with NASA to list the Santa Susana Field Laboratory on the National Register of Historic Places, and so we had exchanged quite a bit of cultural resource information. So I took the white paper and made it into a big objection letter, and I appreciated that very much. And the FOIA request came on September 8th, 2020. The tribe objected on October 29th, 2020. And NASA is just getting around to redacting and releasing the documents, well, actually this month. So it's been over a year in process. Even though we asserted confidentiality under the National Historic Preservation Act and ARPA, and a variety of other FOIA exemptions, really only thing that we were able to successfully protect were locations. So you have trinomials that list each one of your cultural resources that have been mapped and filed with the, well, in our case, the Central Coast Information Center. But all I was able to successfully redact were a few photos and a little location information. So it really wasn't a very satisfying experience. I was hoping to get rid of all the trinomials and any mention of any of the cultural resources. And, that kind of brings kind of into light the entire problem with cultural resources protection, because we protect cultural resources by keeping them secret. But then again, we have to go before these agencies and try to convince the agencies the cultural resources are significant by releasing information about the cultural resources. And so then we get all these pot hunters, essentially, people who are, who like to go hike and visit native caves, and they just don't realize the amount of damage they do. So is that good enough, Lauren, or do you need more?
Oh, I'll be back. But I will first turn it over to Dr. Teeter.
Hi, everyone. So, I want to, thank Sam and Lauren for taking on and being willing to share their information about this problem, about confidentiality. As a NICRA coordinator and someone who works in cultural resource protection, there's a lot of times when we are working directly with tribes and consulting with them, both under the law and through NAGPRA or through FECA or NEPA, and they're sharing very private information. And while we all have different techniques on how we try to protect that, mine is to not write anything down, which is good and bad, right? One, it protects the tribes because whatever they say is not being then misconstrued. But secondly, it means that it's then not documented for use later on. So I know that some people by practice will choose one or the other. But what I found with tribes and talking with tribes is that those processes have different ramifications, and that many tribes, especially in the NAGPRA context, were being penalized and misunderstood in their conversations. So for instance, so that you have a better understanding about what we're really talking about, tribes will come in and consult with me or with my staff about objects that are from their traditional homelands for potential requests under NAGPRA. So they're not, anybody who comes, which may be a Native person, may just be a staff member for a tribe, may be a cultural bearer, but may be a specific cultural bearer of a certain kind. So they're not necessarily walking in with having a downloaded brain of Shumash or whatever else, 10,000 years of knowledge now downloaded in your brain. They're representing the breadth of their knowledge. So they may have other people they're chatting with, they're looking at objects, they're chatting. The person from the museum is then kind of sometimes overhearing the conversation they're writing down. Oh, well, at 3 p.m., they said they didn't know what they were seeing, or at 4 p.m. they said that it's this and it's not burial. So the tribe doesn't get a say on what happens necessarily unless they get really aggressive and say, like, I don't want any notes taken, or I've seen tribes will speak in their own language in order to prevent this sort of overhearing or listening without permission, and then misconstruing. So it's not like, okay, they're listening to something and now the museum is going to send those notes to the tribe to verify that what they said was correct, that they get a chance to redact, that there's like a formal process. Under CEQA, NEPA, or CRM, there's much more likely that that process may happen. But definitely within museums and universities and agencies, we will often see that it's much more loose and sort of how that process occurs. And so tribes were getting penalized for that over and over again, to the point where people were literally saying, like, hey, I heard you say that this object wasn't yours. They could have taken a photograph and gone back to their elders council or their cultural committee, and they said, absolutely, this is my object, or you're a man, but this is a female object, or vice versa. And then they come back and they say, yes, we would like to have this item under NAGPRA for this reason. But now the museum has been prejudiced in their own mind about that issue, right? So this is so that was my concern as a NAGPRA practitioner, was that I was seeing a lot of damage being done to tribes, often inadvertently, but sometimes on purpose, especially with places like Harvard, Peabody, the University Museum in Pennsylvania, where they actually did make decisions and different tribes had expressed their frustration and had to bring their challenges before the National NECA Review Committee, sometimes good and sometimes bad. So we definitely had a big problem. And then certainly in CEQA, we were seeing the same kind of issues. So being able to have Sam's help and your help, Lauren, especially for taking on the issue, and then having tribal representatives who have this experience, right? Mine is secondhand. I can tell you what I've experienced, but I can't tell you what the tribe's experienced. You got to have the tribes for that. So really, really happy that you all took this issue on and that it's at least being able not just to deal with this issue, but like Sam said, now that you have that white paper available, then all tribes, whether they're federally recognized or non-federally recognized in different occupations, whether it's in court, cases, or it's in a CRM issue or family court, like all of that has been the ability to make a better outcome and protections for tribes. So I'll stop there.
It's funny, isn't it? Because there's the information centers all throughout California that have all the recorded archaeology. And some of them, like at the one at UCSB, has been really friendly to the Saninas Band of Chumash. But then I make a request to Fullerton and they don't want anything to do with me or the Saninas Band. It's like starting over, and I'm like, it's tribal information. The tribe should have access. They go, well, you need to hire a registered professional archaeologist. I'm like, well, maybe. I mean, I'm not adverse to that, but this is tribal information. We're not going to misuse it because, it's the tribe's history. And we're always struggling with this.
Yeah, that specific label of expert definitely appears to pop up over and over again as a weapon against tribes, and how tribes are inherently incapable of being an expert on themselves, both for like lack of capacity, but also because of self-interest, which is interesting. Well, I have.
It's just to say, like, and there's this idea that somehow they're going to then not, like, going to share this information, like somehow we'll sprinkle it out there to the universe, so they can't be trusted to manage who should have access and who shouldn't. So I always like that one too. Like, really?
Yeah, I'd love the citation for the tribe that blew the whistle on themselves. Well, I'd love to the extent this is even feasible, and I direct this question to both panelists, but especially Sam, are there any confidentiality protections that you do find useful and you find yourself relying on, or are they all sort of not very meaningful?
It's more your relationship with the federal agency or the state agency. I mean, there's enough out there so that a friendly agency can try to protect your information, and an unfriendly agency, there's enough out there they can ignore you. And very few tribes really want to litigate this, because isn't that like the most public forum ever in the history of the world? So, that's why I like to keep consulting over and over again with agencies in our sphere of influence, because we establish those relationships. And then when a confidentiality issue comes up, they're much more cognizant of the importance of the information to the tribe. I send out a lot of letters demanding consultation, and a lot of crickets I get back in return. We really need to work on elevating the importance of tribal cultural resources to various agencies. And at least with AB 52, we can send a letter out if you're a federally recognized tribe or a California Native American tribe, as listed by the NAHC. We can send out letters to all different levels of government and make them aware of their duty to consult. The flip side of that is, if you don't like getting mail, once you send out those letters, you're going to be inundated with thousands of letters from thousands of government agencies. But the alternative is not to participate in the process. And at least in my opinion, that's worse.
Yeah, you mentioned AB 52, which is a California law. It is Assembly Bill 52. It's an amendment to the California Environmental Quality Act, and it's really established tribal participation in a lot of this decision making for any development on any parcel of land within the state of California, which is cool. Do you think if you were compelled, and I didn't ask you this beforehand, so it's fine not to have an answer, but would you like to see that on a national scale so that this was also applicable to federal agencies?
I think it would improve cultural resource management. I think we have a different regime under the National Historic Preservation Act. So we do end up they're forced to initiate a lot more consultation than state agencies are forced to. Most state agencies just pull the CEQA list, have their archaeologists write kind of a vague letter, and then just list the tribe as a stakeholder when, doing the mitigated negative declaration or the at least initial study. So, but at the national level, we are drawn in to the National Historic Preservation Act Section 106 process. So we already have a little bit of a head start.
You mentioned working with NASA, which I think is sort of a unexpected player in this route. How did that come about? And have you found there to be wildly diverse reactions amongst agencies? Is it purely a matter of educating the agency? Or are there some agencies that have strong opinions about this and operate in different ways?
It turns out that every federal agency has a federal preservation officer who kind of guides them through Section 106 and other federal environmental acts, especially on cultural resources. So, and NASA has almost no experience with Native American tribes. I mean, they just ended up building rocket test stands next to the Burro Flats Painted Cave, which is one of the best preserved pictographs west of the Mississippi. I don't even think they realized it until years later. So they've been somewhat accommodating. But like NASA has to spend a huge amount of money on cleanup. Anything they don't have to clean up like saves them money. So the tribes are arguing against cleaning up all the Native American cultural resources on the site, or less minimizing it, because to clean up a cultural resource or a pictograph it's a nice way of saying destroying. So I mean, we have no illusions that NASA supports Native American cultural resources. NASA just wants to minimize the area of the site that needs to be cleaned up.
Yeah, so that's an interesting and sort of ugly alignment of interests.
That's my area of expertise, ugly alignment of interests. Yes.
Yeah, if I had to summarize the tribal lawyer. You mentioned in that negotiation, if you will, that you were able to redact some photographs, but not all mentions of the geographic locations. How did that sort of come about? How was that negotiation? Did you have an opportunity to dissent, and who was the final decision maker?
As a courtesy, they told me, the NASA Historic Preservation Officer told me about the FOIA. On my own, I stole your white paper and converted it into an objection letter.
We wrote it for you.
Yes, totally. I think if I hadn't have put the letter in, they wouldn't have kept me in the process. I think NASA was under the impression that the Bureau of Indian Affairs was the right party to protect these cultural resources. And as of a year later, the BIA has not responded. Now, so I think the tribes themselves have to intervene, and you can't rely on the Bureau. I mean, I think the Bureau is well-intentioned, but, has a lot of resource constraints as well. So we kind of aggressively inserted ourselves in the process. And as a result, NASA came back to us with their initial redacted documents and asked me if I would review them. I think they gave me like 3 days. So we at least got to participate in the process. And frankly, we're going to post the redacted documents on our website, burrowflatsculturaldistrict.org. Because I mean, if one party has access to them and I wasn't able to prevent that, then every party should have access to it. I mean, and because this really is a sacred and culturally resource intensive site. And up until now, I haven't been able to prove it. So this FOIA actually gives me the opportunity to put all this information in the public domain. So now I can really defend the sites. So maybe it has a silver lining.
Yeah, that's such an interesting juxtaposition for strategies in general cultural resource protection. You mentioned secrecy, but then once the secret's out, maybe a public relations campaign is next.
Yeah.
Well, there's another part of that, which is unless the tribes participate and kind of aggressively so, you never know what somebody's going to view as being important to redact and not. Just like he was saying with NASA, it's this all over the place. So, I mean, if you really think about how much tribes are consulting on different projects, and, and I'm talking about, at least since I've started, sometimes those are like 10 meetings a day now that they're on Zoom. That's, 5 times a week. That's 50 meetings where the tribe is providing some kind of comments. And if some of those comments are then considered to be information that you only want to share in this sort of consultation, narrowly defined consultation process with some level of confidentiality, you're talking about a lot of cleanup. And some agencies are really good. They're like, okay, well, and Sam is really good, and this is a good practice as well, to sort of, write back to the agency as soon as you're done and say, this is what we said, or demand to know what they're writing down and agree to what is being, what was taken from that meeting and where it's going to go. But unless the tribe is being super aggressive, it's hard, and it has a lot of staff, it's hard to stay on top of so many requests, and then so many uses of that information.
I'd like to, well, I guess first I'd like to honor one of the questions in the chat box regarding AB 52. Have either of you found that AB 52 has improved consultation, and does the guidance effort favor tribes more? I see you sort of responded. Go ahead.
I started typing an answer, I thought, but I think that's perfect. Hey, so the problem with AB 52 is you got to get the notice to the agency before you get the notice that they're scoping the environmental document. So you got to be a little psychic to figure out which agency is sending you the notice. And now I have a theory. I've created the AB 52 project by project notice. I believe I'm allowed to exercise AB 52 on a project by project basis after I get the notice. But frankly, that's not really in the statute. I just do it to be confusing mostly. So, but if you get to the right agency in advance with your AB 52 request, you are in the catbird seat, whatever that means. All right, because then the tribe is able to self-define their traditional knowledge. The agency is somewhat compelled to defer to the tribe's interpretation of their cultural knowledge. So it's a very strong statute under your CEQA analysis that favors the tribe if you get it to the agency in advance and they take the time to understand AB 52.
Yeah, that deference to tribal knowledge, I think, is one of the stark points of contrast compared to federal approaches to traditional knowledge, which is interesting. And it's still relatively new in California. So I think we're still seeing how that deference is actually playing out, but it's certainly one of the strongest iterations that I've seen. Yes, it is it's related. It's exactly the California version of an environmental impact statement.
It's the EIR. It's the Environmental Impact Report, the California analog to the Environmental Impact Statement. Yeah.
Yeah. I'd like to transition a little bit to some more of these tribal strategies for mitigating their release of information. Dr. Teeter, I wonder if in your experience, particularly as an institution working with tribes, what strategies you've seen tribes employ, and then what strategies you've sort of employed as an institution to try and mitigate some of that exposure.
Well, I mean, what I've seen tribes do pretty effectively is switch to speaking in their traditional language. And yeah, that helps out quite a bit. You know, and really just kind of keeping things either written down and then not having conversations in front, or mandating that the person in the room from the institution not record, not write anything down, you know, so that you can really kind of get people to focus on you during that time. And then you can work on creating a summary later on. And the main thing is to consult. So if institutions then consult with the tribe ahead of time, how would you want notes taken? Do you want to summarize that, you know, and agree upon it? Who's going to have access to it later? All of that information is super important. And I think something that just, especially museums, don't tend to do very well, and certainly agencies don't do very well. They kind of just do what they want and feel like they can then dictate what those terms are. And the issue that we were having is now the new CalNAGPRA regulation required an audit. And so we were faced with the state coming in and wanting all of the documentation related to consultation and anything about a case that UCLA was involved with for NAGPRA. And that put us in a weird position, right? Because now all of a sudden, things that we thought would not be released to anyone, where they were kind of private and useful, were going to go out to the public and had not been given permission to be released or been looked at by tribes, right? 30 years of NAGPRA, that's a lot of information that hasn't been vetted by tribes before it goes out the door. So that's what really kind of made me pause in terms of what we've been doing in the past and what we should do going forward. And then how much gets archived? What gets archived? How do we bring tribes into the other side of this conversation to determine how NAGPRA cases are being handled and shared? Sam, thoughts?
I agree.
I wonder, Sam, if from the, you know, not antagonistic, but certainly a strategic lawyer's seat, you mentioned, you know, using some of the language in the white paper that helped really motivate NASA to include you in some of the notice that they might not have otherwise provided. Has there been other like language or memorandums of understanding or any other types of strategies that has helped to push confidentiality protections forward a little bit?
Well, we have started putting confidentiality notices on all of our consultations.
Oops, you're muted. There you go.
Sorry about that. We now put a FOIA on federal documents for federal consultation. We put a FOIA exemption statement at the beginning saying that none of the information contained therein can be released pursuant to NHPA 106, ARPA, American Indian Religious Freedom Act, and other federal statutes. What at least highlights the issue for the federal agency at the front end, Sometimes you enter into MOUs with the various agencies. Usually they're about consultation, to have at least an annual meeting and what to do if there's an unexpected discovery of cultural resources or human remains. So you could add confidentiality to that section. And lately, the federal agencies have been asking the tribe to sign confidentiality agreements to get copies of the cultural resource reports for federal projects, which always blows my mind, actually. It's kind of like, really? We're going to release this stuff? And so I guess you could have the tribe ask for confidentiality, especially with developers. I think other governments probably be hesitant to sign them, but third parties, developer types probably are used to that. I know at Chumash, I have a whole file of confidentiality agreements. I think they're totally unenforceable. But I mean, it's a certain comfort to have one in the file.
Yeah, this is an interesting area of law where a lot of this, like you said, isn't litigated. A lot of this front end protection ends up being marginally useful, and that's good enough sometimes.
Well, as in-house counsel, you're protecting the tribe, but you're oftentimes protecting yourself. So you have to be doubly careful.
Not terrible advice, future attorneys that are on here. Not terrible advice. To push back a little bit, a lot of like the Freedom of Information Act, for example, right, wasn't designed necessarily to target tribes and mine for traditional information. It's about transparency. It's about ensuring that the government is making good decisions and is accountable for that. Shouldn't tribes also be held accountable too? Don't we have a public interest in ensuring that tribes just don't have a veto power over quashing development? How can tribes provide assurance without, just mandating that everything go into a black box?
Well, there are times when the tribe is solicited by people opposed to a project to have a tribal opponent to the project. I'm kind of I'm negative on that, because all the tribe really has is its reputation. And if people know that we're a front for the Sierra Club, for example, then it's going to tarnish our ability to independently defend these cultural resources, because the Sierra Club's not going to help me, all right, defend these cultural resources. So we have to use our goodwill carefully in all these projects. And then at least I try to be reasonable, and we really want them to avoid the cultural resources if possible. And I find data recovery to be unnecessarily violent to cultural resources under any circumstances. But even then, sometimes they have 3 votes on the board of supervisors, and it. So sometimes you just got to take what you can get. If they have a majority of the supervisors, and the supervisors, it's a county level project, then I mean, either I'm going to spend the money to litigate the project, or I have to get the best outcome possible, given the fact that they've already turned the decision makers. So it's complicated.
I wonder if there are instances, especially in the preservation of information, which might incentivize the release of information when there are more than one tribe, when tribes are in conflict, when maybe multiple tribes are claiming cultural affiliation or disagree about how a cultural resource might be protected or mitigated.
Well, whenever the tribes disagree, the decision makers stop listening to the tribes. I mean, because they're not going to arbitrate that And their position is if the tribes can't agree, then they're not gonna do anything one way or another. I mean, that's the worst case scenario, really. I mean, even at Santa Susana Field Lab, I organized or tried to organize all the non-federally recognized tribes to come under the Section 106 umbrella of the federally recognized tribes so that we could all have consensus decision-making and not give the appearance of conflict, even though, well, any group of tribes, there's going to be a little bit of conflict.
Yeah, that's interesting. It makes me think that a lot of these processes are almost designed to really take advantage of that conflict, and that there isn't a forum, and it's probably on tribes to really ensure that this forum exists to allow tribes to really come to a consensus and strategize about how we can collectively protect our own interests.
I mean, the classic example, may I say the word Berkeley without being injured, is the ability of Berkeley to prevent repatriation of human remains by creating false conflicts between tribes for years. Oh, and if Jordan, if you're Jordan Jacobs, if you're listening, I'm talking about you. Thank you.
And I was gonna, not use the B word, but I will say that what you do end up with is this sort of arbitrariness by individual, so that you sometimes end up with an institution having this like either very loose, or having a very loose or having a very strict determination of the law. And it's not necessarily that the agency feels that way, but it's an individual who's interpreted it that way. So you're kind of being stuck, the tribe is being stuck, where an individual will say like, well, we only want to talk to tribes if they're in one consultation meeting, or we only want to talk to tribes if they're in singular consultation meetings, or we want proof that every single tribe has similar standing or relationships with the cultural resource or the ancestor. So this kind of like waxing and waning, that's not in the regulation. This is their interpretation. So someone like Jordan Jacobs can dictate the route that an agency has. That can be very, very difficult, make it very difficult for a tribe. And then they go away, and then all of a sudden, it's like the clouds part and the sky is blue again. In the same, it's been easy for me to institute, so I'll say the flip side. It's been very easy for me to work very well with tribes. I have Angela Riley in her support, I had Carol Goldberg in her support, and we were able to do a lot of stuff creatively and towards the return of ancestors because we had, individual control, and it really was my decision. And they followed whatever I told them. And so it's the good and the bad, right?
Yeah, I mean, just like all things, but it seems so prevalent here that well-intentions and the right people really matter in all of these positions. You make me think about, the fact that there is so much opportunity within these statutes, particularly within confidentiality, that there's real opportunity for tribes to be a lot more proactive in dictating their terms, that there seems to be a real need for tribes to come to the table with their own consultation protocols. I know that some tribes are developing and implementing their own information databases where they're establishing tiers on the types of information and the controls of confidentiality that those have. I wonder if in either of your experiences, some of those tribal mechanisms, whether it is protocols, within the code, whether it is terms dictated in like MOUs that you mentioned, Sam, whether it's those type of information controls that maybe some of the tribal archivists or cultural resource protectors are using, if any of those have really bubbled up to the surface as effective, or potential areas where you'd like to see tribes more actively engaged.
No one knows what's going to work. I mean, so we sort of just kind of do multiple actions. I mean, you'll find me demanding government to government consultation simultaneously with triggering federal or state cultural resource protection statutes simultaneously, and hoping for the best. You know, if I have an MOU, I'll trigger the MOU. Most federal agencies under Obama have created tribal consultation policies, which they updated, which they're in the process of updating under Biden. So most federal agencies have a path. State agencies, ever since Jerry Brown's B-10-11 executive order, have started doing consultation protocols as well. And the current governor, Governor Newsom, has extended that consultation policy. So a lot of agencies have their own rules, and you can use those against the agency itself. Now, state and like local governments and counties have nothing. I mean, they're, you know, you just have to like make friends with the supervisors or with the city council, and hope that at least you have one friendly on every area of government in your sphere of influence.
Dr. Teeter, I wonder if you've encountered any tribal strategies that proved somewhat more effective than others.
I think we just did, you know, what Sam said, like it's, you kind of have to throw a bunch of things to get out there and hope that one of them works really well.
Hey, we started negotiating with the Navy. All right, it was the Luceños and Chumash. I mean, I flew to the Department of Defense. They actually have a Native American liaison. I met with him, and he told me he was like in a closet on some weird part of the building. And he said, he told me he'll try, but it's hopeless. And then finally, I had to appeal to the congressman on the Armed Services Committee to bring it up at the committee hearing with the, you know, the head of the Navy. And then finally, we kept shaking the tree at every level, you know, both with the president, the Office of Intergovernmental Affairs, with the Department of Defense, with the local Navy base. Finally, someone just got fed up with what a harassing process we were undertaking, and finally returned a call and a letter. So, but that was like a 3-year process. So you really have to be prepared to be rebuffed numerous times. I think to become Jewish, you have to be rejected 4 times by the rabbi. So this is a similar process.
It's so deflating. This, you know, it's hard to put into context, I think, right? Because the truth is we have access to some cultural resource protection mechanisms that didn't exist before. So merely like the ability, even the terminology, right? A traditional cultural property, cultural resource, a sacred site, you know, it is better than it used to be. And right, you know, here, this panel really talking about the traditional knowledge as its own cultural resource worth of protection. And yet it seems even in the face of these protection mechanisms, the overall philosophy remains the same, that these are just not highly valued, and the trickle down of these statutes just hasn't quite taken place to the extent that we need it to yet.
I think the best tool you have in your arsenal is stability of tribal government and stability of professional staff, because I've been at San Ynez since 2005. So if you piss me off, you can expect a 10-year campaign. All right, I will not give up. All right, and I've had a stable government that supports all of our campaigns. So when we couldn't get an exemption for Chumash fishing rights in the marine protected areas off of to the Channel Islands, I bombarded them for 8 years. I was a guest of honor at the Fish and Game Commission. So you just cannot give up, and you need to have a supportive government that lets you keep persevering. Do you want to take this TCP question, or do you just want me to type it? All right. So a traditional cultural property, there's this National Park Service publication 38. It's a legendary document written in part by Tom King, who is a legend himself, to create the traditional cultural property analysis, which is basically a series of stories from tribal people talking about their connection to an area or an object or an area. It's not hard to do, but it's hard to get approved. I mean, anyone can write a TCP report because, well, anyone who has the confidence of tribal people and can get them to open up about their stories can write a TCP report. So that's hard, all right? And so we did a TCP study for the Santa Susana Field Laboratory, and then we wanted to get it listed on the National Register of Historic Places. Well, it turns out there's the Local Government Act, which kicked us back to the County of Ventura and their Historic Resources Commission, those were 2 8-hour hearings, and they split. The Historic Commission voted in favor of TCP listing, and the County Board of Supervisors hated it, and they voted against it. So then we have to go to the State Historical Lands Commission in Sacramento. And of course, they were unanimous. They were anthropologists. Then the SHPO had to approve the application. Then it had to go to the keeper of the National Register, who said we had some boundary issues and kicked it back. So, I mean, that was a 3-year process. And now we have to start over again. So, anyway, I encourage you to do the work for the TCP analysis, because the TCP links or the archaeological district, you can take all your sites and create a district out of them, and it almost gets you to the same place. And that allows you to protect a region as opposed to individual sites, which gives you a higher degree of protection. And most of the statutes under federal and state law just say you have to be eligible for listing on the National Register. So you don't really have to go all the way to the keeper of the National Register, unless you just have 3 years of your life that you just are not doing anything. So, so TCP works. Archaeological district works. Don't forget traditional cultural landscape. All of those are on the National Park Service website, and they have their own little landing pages. Or you can call Tom King for a small charge.
I thank you, Leah, for sharing, and I encourage, if you have questions, please feel free to type in. You had briefly mentioned the Sierra Club and other sometimes allied, sometimes antagonistic counterparts out there. In regards to sensitive tribal information, but then also just generally in the work of cultural resource protection. Have you found that, relying on allies is beneficial? Have they proven to be more, work than it's worth? And has there been any surprising exposure that you didn't anticipate when it comes to the release of information?
Well, forgive me for being cynical, but in California, animals come ahead of tribal people, all right, as a general rule. So I can, if it involves a mountain lion, I can accomplish anything in California. But if it's a tribal historic site, I think you got a 50-50 chance of prevailing. So I do try to link our traditional cultural resources to cute animals. We've done additional research, and mountain lions are part of the sky god and are revered by Chumash people. So we try to bootstrap animals and maybe endangered plants into our analysis. And if you're doing a TCP, for example, or a TCL, then all of them are relevant as part of the historic nature of the property. And so you can bootstrap them in. The only problem you have with these agencies are like at Santa Susana, I mean, these, the Sierra Club wants to clean up, like devastating cleanup, you know, scrape all the soil, but all of the Native American history is in the soil. So, you know, we are at odds with them just because, you know, they want to be extreme and we want them to be judicious.
I wonder, Dr. Teeter, if you found any surprising allies or not allies in your work from an institutional perspective.
I guess the biggest thing that I found more surprising is how much people are willing to kind of, or think that tribes have this like amazing power that if they can just throw a human remain over a fence, that somehow that's going to like trigger everything. Like all of a sudden you'll have protection because there's a burial there. So I have gotten so many phone calls from people who are saying, isn't there like a burial that was found here? I mean, they really don't want the development. So they just want to use the tribe. So whether it's like a community organization or a Sierra Club, and then as soon as they aren't useful, then it's like, oh, well, then, you know, we forget that the tribe exists.
Yeah, it seems like our neighbors are very slow to becoming indigenizing themselves to this landscape. Bless their hearts.
Yeah, exactly. If only, I mean, if only it took one remain in order for a project to get shut down, we would be in a very different position than where we are now. You know, one of the first things that I realized when Playa Vista was being developed was that even though there were literally hundreds, almost thousands of remains that were encountered in a cemetery, that the developer refused to acknowledge it as a cemetery because it hadn't been written into state law with that definition. And it didn't go through the statehood of California. And so unless it went through continuous use until it becomes a state, then it doesn't matter. And so it's amazing how many ways in which developers or people have been able to kind of skirt the law in such a way to their benefit.
We have a couple cool questions. I'll try and throw this out in our last few minutes. I don't know if either of you know anything about the NEPA 2020 rule and whether that has any impact on confidentiality and tribal consultation.
It didn't affect us, so I don't think so.
I haven't heard anything either, but I definitely cannot claim expertise in that area.
I mean, even the Trump administration revisions didn't go to confidentiality. They just went to speeding up the process and kind of forcing the agencies to make a permitting decision within a certain finite amount of time.
Well, we have about 5 minutes left, so I'd love to give each of you an opportunity to give your final thoughts, including if you have any recommendations or good thoughts that you'd like to send to our tribal practitioners for how they can leverage both their attempts to protect their cultural resources, which include their traditional knowledge.
So just let me tell you that I'm a one-man in-house counsel, so we do everything at Chumash. But the best parts of my job are NAGPRA repatriations and protecting cultural resources. And so this is the work of the angels, all right? And it is worth whatever time and resources you can devote to it, all right? Now, keeping the casino operating does keep the electricity on, which is also helpful. But this is the stuff that protects the history of the tribe and the legacy of, well, in my case, the Chumash people.
Thank you. Dr. Teeter?
Can I say ditto? Because now I'm working for them too. Yes, NAGPRA is my favorite part of the work that I've done at UCLA and cultural resource protection, and being able to work with tribes on a whole host of issues where they really have the motivation and just don't realize that they have the ability to kind of dictate those terms or be more involved in sort of the shaping of those terms. So it's definitely a labor of love. And to the person who, Leah, who was talking about writing the TCP, yes, it is a lot of work. And when it goes well, then it's absolutely fantastic for just those reasons.
So I'll put
So thank
my
you.
contact info in the chat box. Does that work? Or are you going to send it out? And so if you need a free lawyer, well, there's not very much of me that's not committed, but if I can help, I will. All right.
I can't reiterate that enough. These both Sam and Wendy happen to be titans in this field, and they also happen to be incredibly giving and really, I think, have the best interests of Indian country at heart. And so from the bottom of my heart, I just want to thank you both for participating in this panel, but more importantly, for working in this space and for sharing your expertise. This is a exciting and yet fraught area, and so it's really nice to both highlight the barriers that we face, but also strategize about how we can get around those barriers. Yeah, you're going to regret that offer, Sam, but yes, you should email him. He's very responsive.
And we're going to set up a GoFundMe page for Angela to get a new computer.
To all of our attendees, thank you so much for joining us. We hope that this has been helpful. The white paper, we put a link. It's available on the UCLA's Native Nations Law and Policy Center webpage. This clinic, My Position, is funded by the San Manuel Band of Mission Indians, and the goal for this clinic is, to do projects on behalf of Indian country, including projects like this. And so this white paper is free and publicly available to everyone. So please feel free to use it, to cite to it, to request additions or modifications. It is for you, and so we hope that it will be beneficial. This is part of a fall speaker series. This is our second of 3 events that we are hosting, 4 events that we are hosting, but our third is going to be in person at UCLA. And so if you are on campus, we hope you can join us for Brett Shelton's presentation on peacemaking that will be taking place October 26th, I believe. And on November 17th, we will be back here on Zoom, coming back to cultural property, but this time looking at tribal protections for cultural property, centered around a paper authored by Professor Angela Riley. It's going to include another all-star panel of scholars and practitioners, and so we will be sending out notice for all of that. In the meantime, we hope that you will be well and enjoy this beautiful fall weather, at least so it is here in California, and see you next time. Thank you.